Hi, this is Jonathan Ginsberg. I'd like to talk to you today about debts that will survive your Chapter 7 bankruptcy. And what I mean by survive is that even though you file bankruptcy, these debts will remain debts even after your Chapter 7 discharge. So I think one type of debt is a credit card debt that is co-signed. And it won't survive as to you, but it will survive as to your co-signer. So in other words, if your mom or your sister co-signed on that MasterCard or Visa, you file bankruptcy, it will be discharged as to you, but after your Chapter 7 is over, your discharge is issued, your case is closed, mom or sis is going to get a nice letter from the credit card company saying you owe us 100% of this debt. Even if mom or sis didn't buy anything with that card, but if they co-signed, again, there's a difference between being a co-signer and an authorized user. If they are a co-signer, they are 100% liable for all of that debt, even though you charged all of it during the time you had the card. So if you have co-signed debt, it will survive as to the co-signers. If you have a secured debt, like a car, house, furniture, jewelry, that you sign a written reaffirmation agreement with, then that debt will survive the bankruptcy. And basically, what that means is that when you reaffirm, is that you're saying, I will remain personally liable for this debt. I'm reassuming this debt after 60 days, then that becomes permanent. So you need to really think very closely and very hard about reaffirming. Under the current law, your attorney has got to be involved in that process. But if you reaffirm a debt, then that debt will survive bankruptcy, become a permanent debt. You cannot get rid of it at least for another 8 years, because you can't file another Chapter 7 for 8 years. So think very, very carefully about reaffirming, but that would be the type of debt that survives bankruptcy. A secured debt that you do not reaffirm. So let's say you've got a car or a jewelry that you choose not to reaffirm. Your personal liability would be gone. However, the lender's claim on the property would remain. So in other words, if let's say you have a loan with Ford Motor Credit on a car, you file bankruptcy, you do not reaffirm that loan, your personal liability in the loan is gone. However, Ford still has a lien on your car and can repossess it. And in fact, they may very well repossess it, because part of their consideration in their contract is your personal liability on the loan. And that's why, by the way, if you do not reaffirm a secured debt like a car or a house mortgage, then you will not see the advantage to your credit. Your credit report will not show that you've made payments, because you have no personal liability. So it's kind of dangerous in some respects to not reaffirm if you've had somewhat of a spotty payment history. Usually lenders rather have the money than the property back, but realize if you don't reaffirm, the lender, after the bankruptcy is over and the stay that is applicable while the bankruptcy is in force is lifted after discharge, they can come pick up your car, they can start foreclosure. So it's wise to talk to your attorney about whether you should reaffirm, what happens if you do, what happens if you don't. But the property lien will survive bankruptcy. Tax debts, especially recent tax debts, and recent is anything that's really 3 years old or younger, that will survive bankruptcy. That's considered a priority debt. That will survive bankruptcy. The IRS or state does not have to do anything. It's automatic. And there's other rules regarding tax debt if you haven't filed your returns on time, things like that. But tax debt, especially recent tax debt, will survive. There are some tax debts that are dischargeable. If it's really old tax debt, there's no lien, those can be dischargeable. But if it's newer tax debt, if there's a tax lien, it's going to survive the bankruptcy. Again, this is an area where you ought to talk to your attorney. You ought to get some advice, maybe look at a tax transcript to see what's going to survive, so that you know going in, and you can make your appropriate decision about when to file. I've seen cases, and I've been involved in cases, where by waiting a couple of weeks from the time my client came in, we were able to discharge thousands of dollars of tax debt because it became stale. Had we filed a week earlier, it would not have been discharged. So it's important to know the dates and to know when your tax debt will become dischargeable, and you've got to balance that out with if they filed a tax lien. If the IRS or state has filed a tax lien, those liens we can't get rid of those in a bankruptcy. So again, those are things you need to really talk about your attorney. And finally, debts that are deemed non-dischargeable under Section 523 of the Bankruptcy Code, those will survive bankruptcy. Examples of that would be criminal restitution, domestic relations debts arising from a divorce, child support, and so forth. Student loan debts are non-dischargeable. The only exception to that would be certain private student loan debts that might be dischargeable after a certain period of time, or tuition loans, things like that, that could be dischargeable. Again, very, very unique situations, but there are some. And again, normally with student loans, unless you can show extreme hardship, then it's not going to be dischargeable. So there are, again, a category of debts in Chapter 7 that are going to survive bankruptcy. It's wise to talk to your attorney. I've got a number of them written up on my website here, but again, I think it's important to talk to your attorney to make sure that you're on the same page and you know what's going to happen after your case is over. So again, my name is Jonathan Ginsberg. I'm an Atlanta bankruptcy attorney. Hope this has been helpful. Until next time, I'll talk to you soon. Thanks.